So we're going to try to get back on with Bill Farias. I think I said his name wrong when I first went on, but hopefully the phone won't explode. It's not getting too warm. We won't get cut off again. Let's try it again. Bill, if you can hear me, I just direct message you. And Chris, let me know if you see him come into the room. But anyway, sorry everyone that live just like cut off in the middle. Hopefully Bill will be here any second. As I'm waiting for him, I'll just say that I had a really good day in family court. Was it yesterday, Chris? I think it was. Yeah. Oh my gosh. It was so good that I actually felt like we didn't even have family court yesterday. Okay, here he is. Okay. Sorry, Bill. I'm going to put you back in here. Sorry about
No
that.
problem. I thought it was
All right. No, it said a thing like your phone's getting too hot. So hopefully hopefully it cooled down in a
we don't want phones blowing up live.
I know. If it happens again, we'll just do part 3. So Chris was saying start all over, but I don't think we need to start all over because hopefully we'll stitch it together, just do 2. But so I had said about my 90-ish court appearances, and right before I got caught up, you said you have kind of an unusual situation. So why is it unusual?
It just sounds like it's very intense, and you've been to court a lot, and that is a small percentage of cases. I understand that people in this group, some are experiencing that, but it is overall an unusual situation. It's a small percentage of the cases we deal with.
Oh, well, that's good to hear. Yeah, mine is really about enforcement. I did get wonderful orders years ago, and now it's just trying to get a judge to make some deadlines and consequences, but we're definitely making progress.
Good.
But anyway, yeah. So so you were talking about the return on investment, and then I don't know if that's the same as the spectrum of risk, deciding what's worth it.
Well, the spectrum of risk, it goes to whether people should be handling issues on their own in family court. And so the best way to think about it is generally the longer the marriage, right, the more there is at stake financially, both in terms of assets, support on the line, and when there are kids involved, it's generally riskier, right? So if people come to us and it's a short-term marriage, there isn't much in assets, they don't have kids, they're low on the risk spectrum. On the other side of that spectrum, you have people that are married 20 plus years, hundreds of thousands, millions of dollars in assets, multiple little ones, parenting time has to be sorted out, custody. And so you have to figure out where you are on the risk spectrum to determine whether it makes sense to invest in representation and how much. And so that's the basic concept. And where we've seen this go south a lot is people who are on the higher end of the risk spectrum try to represent themselves. It doesn't go well. And then they call us to try to dig them out of it. And in some cases, it's impossible.
Okay, so pause there and tell us why you think for a lot of people who represent themselves in the beginning or in these situations, why doesn't it go well? What are some common mistakes that people make when they go pro se?
Well, I mean, first of all, there is advocacy involved, right? I mean, if you're in a contested hearing, people go to school for this, and they go to school to learn how to effectively present the facts and tell the story and put the best foot forward and be persuasive. And some people aren't persuasive because that's not what they're good at. So they go in and they know their story well, and they're passionate about it, but they don't convey that effectively. And so they may end up with a bad result. I mean, this even happens in mediation. They go into mediation, they try to do it themselves, they don't do it effectively, they get a negative recommendation, and then what the other party hears is, hey, this is good for me, and I need to pursue this. And so then the person who went out on their own is in a tough spot because now you have to try to reverse that, and it can be very difficult. And so that's the basic concept.
Yeah, I'm thinking, and I don't know if I ever told you this, but so my background was as a high school English teacher. and with a focus on writing because I'm also a professional writer. And so I really enjoyed teaching the art of persuasion in terms of writing, which is now transformed into persuasive speaking. And what you said reminds me of a lot of things I tell our clients, how, there's really three parts to persuasion, especially when speaking. The first is called logos, and that's the evidence and the truth and the facts. But that's not the whole story, because it's the second part is pathos, which is what you talked about, is the emotion surrounding it. So we'll say to our clients, like, if you're hysterical, it doesn't matter what the truth is, because no one's actually going to listen to you.
Correct.
And that's where presentation comes in. And the third part is ethos, and that's your credibility, and also everything with the setting and the atmosphere of the court, the decorum, like, and we say the way that you would tell your story to your friend is not the way that you would tell it to a judge. Like, there's a lot more involved. And so all those three things have to come together properly to actually make a case. So I think what you're saying is, a lot of people think, oh, because the truth is on my side, then my case is so great. All I have to go in all I have to do is go in and say what happened. And that doesn't necessarily guarantee a positive result at all.
No, and it's not that simple. And understandably, it can be very difficult for pro se litigants to detach emotionally, right? And so to present something effectively, if you're so emotionally wrapped up in it, you're in effect sort of losing credibility, right? Because if a judge sees there's too much emotion in here, then they're going to be very careful about what they accept and what they believe. And so going back to this spectrum of risk, you just have to be, at the very least, ask these questions before you decide to represent yourself. Like, how much is on the line here? Am I really well equipped to do this? And remember that if it doesn't go well and you walk away with a negative order, it's not as simple as, let me go hire an attorney to go explain to the judge what happened. Many times that's just not possible, and you're stuck with a bad precedent, and then it's an uphill climb.
Right. Yeah. And I know, at least where we are and what we've experienced, our clients' experiences, especially with custody, when there's an order, you can't just go back in with an attorney or not and say, we need to change it. You usually have to wait at least 1.5 to 2 years. Otherwise, it looks like you're just disagreeing with the order. Do you find that's true?
I find that's absolutely true. And not only, it doesn't only have to do with time, it also has to do with the fact that generally judges do not want to make changes. So they will only make changes when they have to. And so unless you can go in and present to the judge that there have been significant changes that warrant the judge making a move, they're going to opt to just leave it as is, and I think a lot of it is they want to minimize disruption. So even in some cases where it might be best to make a change, judges are going to err on the side of keeping things as is unless they absolutely have to step in. And so that's another reason to be careful, especially in your first couple of events in court, to make sure you lock in a good order. Because if you don't, it's going to be very difficult to convince a judge to change it.
Yeah, and we always think about it as the foundation of the case. Like, what do you have as your foundation? So that actually makes me think about another topic that we talked about, which is isolated incidents versus patterns of behavior. Do you want to talk about that a little bit in terms of making a case?
Yeah, sure.
Because people sometimes get really excited. They'll be like, they just did this horrible thing and now I'm going to win.
Yes. So this is very important. And it's the reason that when we onboard people, we ask that they keep a log of incidents, of events. And the reason is anyone can have a bad day, anyone can make a bad choice, and judges recognize that, right? I mean, judges are people, they deal with people all day, and they know that somebody doing something once or saying something once can sometimes not be very significant. Now, on the other hand, if it's happening repeatedly, then it's something that it's much more likely that the court is going to act on it and give it significant weight. And so this goes back to keep track of everything. Certainly, it doesn't mean that the incident is not important or that it won't have an impact. Obviously, it depends on the magnitude. There are some incidents that one single incident is enough to go in. Absolutely, especially when you're talking about abuse and neglect. But generally, you want to keep a log, keep track of what's happening, and remember that one single incident is not going to, in some cases, persuade a judge, that you have to build a case.
What are some things that you find are pretty insignificant to keep logs of? Because we get a whole range of stuff, and some of it, no offense to anyone, but it's a little bit petty. It doesn't matter, and they put a lot of weight into it, and we have to explain like that stuff doesn't really count, or that's outside the scope of what the court can probably handle. But this is the kind of thing that you really need to keep track of.
I mean, there are a few. I already brought up an example of, somebody returning from parenting time, somebody returning the children a little bit late, and it's an isolated incident, or maybe they the other parent doesn't return a call or a text message right away. And again, it's not a general pattern. Now, if this is happening over a long period of time and it's negatively impacting the child, then that's important. But if the person, I don't know, stays late at work or is having a bad day and doesn't return a call, that's not going to be a big factor, and it's not going to be a big deal unless you can show a pattern. So those are a couple of things that I can think of. Maybe not returning clothes promptly.
That's actually that's a big thing when people will say, I keep buying all the clothes. The kid takes the clothes to the other parent's house. They never return the clothes that I buy. I want to change custody, or I should get, more rights because I didn't pay for the clothes.
Right. So it's like that's not going to happen. You're going to get like a slap on the wrist, or a reprimand. And, is that worth $5,000 and a court appearance? I don't know. Maybe if it's persistent, but certainly there are some minor issues that you have to try to manage. And again, if you're logging and there's a pattern, then maybe at some point it's worth moving on.
Yeah. Okay. Let's talk a little bit about limited scope, or I think you had called it limited assistance and unbundled services. So we talked a little bit about already what people can handle themselves and when they should call an attorney. You said it's hard if somebody doesn't get a good foundation or beginning, and then they want to call an attorney. But what do you have to say about that? Or when is it not a good idea to use unbundled services?
So generally, I think unbundled services make sense if you have some financial constraints and you need an attorney to handle a key piece of the case. Maybe it's the first hearing that you're going in on and you need representation. I think where it can become problematic is when people try to kind of like piecemeal representation. And so they'll get some help at the beginning, and then they'll go out on their own, and then they'll want to come back for some help and some guidance. And what's important to understand is that makes it very difficult for an attorney to effectively handle the case, because it's coming in bits and pieces. And so it's more challenging when the attorney is not able to control the flow and trajectory of the case. And so that's something that we've had difficulty with. We have offered unbundled services in the past, and we still do. Actually, in Massachusetts, it's called limited assistance representation. But we're very careful about getting into these cases where it's going to be in and out, just because, number one, it's difficult to be effective in that situation because you only have so much control. And connected to that, it becomes more difficult to give the client a positive return on investment, right? Because again, it's coming in bits and pieces. You're not privy to everything that's happened. It's impossible to get a full picture of all of the conversations that were had, all of the actions that were taken. And so it's just more difficult for the attorney to guide a case like that. And so that's sort of the limitation. So I think it is useful when there are financial constraints and when there is an important event, especially at the beginning, to help build that foundation. But I think more and more attorneys, and certainly my colleagues, are more hesitant to come in piece by piece and come in and out of a case.
All right. So it makes sense, like at the very beginning, especially because that's so important to get legal assistance immediately. And then we also say to our clients, again, we always say we're not lawyers, but that we would never recommend having a divorce pro se, because you have no idea what you're doing and the whole thing about the spectrum of risk. But that when you already have orders and it's post judgment and it's a very specific thing, then you might have a better chance. But again, that depends on everything, like what you already talked about, how you present, how emotional you are, et cetera. Because it's always difficult to be pro se. And my house is a disastrous mess from all the papers. So,
Right.
yeah, so it's tricky. Okay, so we just talked about how, you don't want to come into an attorney who basically has to clean up someone else's mess, especially on a limited assistance or limited scope. But what about what do you think someone can do in general to make themselves a better client for an attorney? Who are
I
your teacher's pets of clients? Because we always tell our people, like, we're going to make you the teacher's pet of a client. Like, we're going to make you really organized, et cetera. But I want to hear from your perspective as an attorney, which are the clients that you like better than the others? What types of
Well,
people?
I think the clients that are easiest to work with are, number one, clients that are able to rein in their emotions. So, especially if people, if the person has suffered trauma or it's been a difficult marriage, it's very important for that person to get some help and guidance. And we do our best as a law firm to guide them and to comfort them. But in some cases, they require work beyond the scope of what we can provide, right? And that's when it makes sense to get a counselor, at the very least, get a mental health assessment to see if there are any services that can be plugged in, using maybe a divorce coach on the side. So that's number
Yeah.
one. So that's number one, is reining in the emotions and being prepared to at least make an effort to view your circumstances objectively to the extent possible so that you can make smart decisions on your case. And that's very difficult, right? It's easier said than done. But
Oh,
it's
yeah.
very important, and it makes for a very helpful client and an overall very effective party, in the sense that they're not going to let emotions get the best of them. They're going to do what's best for them. They're going to do what's best for their children. They understand that there is some give and take, and they're not so emotionally wrapped up in it that they're going to make bad moves and hurt their credibility. So that's number one. Number two is really communication. That's very important. And again, I think a lot of it goes back to the emotion. When things get difficult, people tend to bury their head in the sand. Like, I don't want to deal with it. I don't want to have this conversation. I don't want to look for this document. I don't. And so you have to understand that when you're delaying, when you're not communicating, you're really just hurting yourself, because you're putting your legal team in a tough spot where in some cases they have to scramble last second to gather and organize this information. And so that's really the second important component, is being available and communicating with your legal team.
So I love that. That's so great and so simple. And I'm thinking too, another thing that we have to work on clients with is helping them understand. We call it the New York reality check, but helping them understand that family court is not a place to validate them, that you don't go to court to get validated, and that no one's going to basically make you completely whole. That there's, and I've learned too, like the money that I've spent on trying to get my orders in for, like I will never get it all back. And
Right.
just accepting that it's never going to be completely, I shouldn't even use the word perfect again, but there's never going to be absolute justice.
No, there won't. There won't be in many cases. And that goes back to being objective and having a conversation with your attorney about, like, what is the purpose of this? What are we looking to accomplish? What can we gain from this? How much is this going to cost? And that's why, and that feeds right into that. I think these conversations are super important, because many people want to say certain things to the judge or get certain things out that are really not going to help their case. And in some cases, it will hurt, because the judge is going to be thinking, you're wasting my time. There are 10 attorneys or pro se litigants waiting for me, and I don't have time for this. And so you have to be very careful about what you are presenting in court and what you're putting before the judge. I tell people you only have so many arrows in the quiver, use them wisely.
Mm-hmm. Yeah, we talk about it like you're going to have 3 minutes max if you're even able to talk. And we got to put together like a really tight commercial. You know,
Correct.
Often says it's like having a commercial during the Super Bowl. Like it has to be really, really good. And then that's it. That's your only chance
Absolutely.
until you go back.
And connected to that, if it's not a great commercial, people are going to tune out. And if you're
Mm,
not presenting what the judge needs to hear, they are going to tune out because they're human beings, right? Like we
right.
want to think that judges are taking, but if, and I see it all the time in hearings where these conversations go off the rails, and I can tell the judge is really not paying attention. They're just waiting,
Mhm.
like, okay, I'm going to give you your time, but this is a waste of my time. And so you have to be
Yeah.
very careful to do that because when you actually have something important to present, you want to make sure you have the judge's attention.
Yeah. And I feel like it was you that recently did a post about or maybe there was something that I saw about mistakes that pro se litigants make, and sometimes it's that they keep repeating the content.
Yeah, I don't
Do you remember?
recall that, but that's true. It goes to you
You've
have to
probably seen them.
use your time wisely.
Right, right, right. Yeah. Okay. So you talked a little bit about making sure that clients have other resources, especially mental health resources. And I know that you guys take a holistic approach. So what other resources, or is there anything else that you think people could use during this divorce process?
So I think that the three main ones are number one, uh, mental health. So we have a team of therapists that we can connect people to. So that's super important for reasons we already discussed. Number two, financial health, right? This is very scary for a lot of people who didn't have control of the finances or are not well versed in financials generally, to be
Mm-hmm.
going out on their own, to have to plan for their financial future. And so that's another area where we like to, whenever possible and whenever it's a good fit, connect them with a financial professional who can help them with that. Also, coaching. I think that's important also. So we do obviously work with clients, preparing them for hearings, but some people who are in very or have been in very difficult relationships or high conflict relationships, they could benefit from someone in addition to the attorney guiding them through it. So those are three areas. We've also put parenting coordinators in place, so help for parents to kind of work out their disagreements, sort of a mediator for custody and parenting time issues. So that's been helpful in the past also.
Yeah. Okay. Chris just handed me a question that someone sent in. How can we collectively work to help change the laws regarding legal abuse?
Um,
That's a
well,
big one.
that's a big one, and frankly, it's not something that I've ever been involved in. I mean, I have a colleague who has a sort of shared custody law before the legislature. So, I mean, that's a legislative question. So I'm
Mhm.
not, there's lobbying involved. So I can't really speak to that, honestly. I've never
Oh.
tried to do that, so I don't
Yeah,
know.
actually, Chris is telling me that the thing that we tell our people too, because a lot of people say, you know, I want to be involved in this movement to reform family court, and we usually say we got to take care of your own case first.
Yeah, and
So let's deal with you.
that is a huge boulder to move. I mean, to get anything done in family court is, in terms of changing law, is very, very difficult. So what I would recommend is, start with calling your rep, your representative, and bringing the issue to your representative's attention, and maybe get it going that way. And then I don't know, maybe if you get some traction online, you may find an attorney who is interested in that and believes in the cause and can help push it forward. Off the
Yeah, I
top of
mean
my head,
that's
that's what I can think of.
I know, and I feel like we're a little bit off the topic, but it's fine. But in Connecticut, where I am with Jennifer's Law, I was involved with it because our old state rep, Alex Kasser, reached out. I can't remember how she found me, but we met for coffee. She talked about how she was going to do something, and within 2 years, Jennifer's Law was a bill, and then COVID hit, and then a year later we did all this live testimony and it passed. So that was really exciting. But it's like what you said, and also I had conversations with legislators in between, but that's what moved it forward, and we're just so proud that Connecticut's the third state in the country to have that.
Yeah, that's awesome. So I think you're in a better position than I am to advise people on how to get laws passed.
Yeah. That's another topic. But let's get to the fun stuff. Let's talk about some of the crazy questions that you get as a family lawyer, because I think that's how I found you in the first place. Is I love this post that you had up there, and I was just like, really? Somebody asked that?
Yes.
So tell us some of the crazy questions.
So my favorite question of all time was from a woman who was getting divorced. We were at her divorce hearing, and she was asking me about the nisi period in Massachusetts. So what we have in Massachusetts is what we call this nisi period, where people are not technically divorced for another 90 days after their divorce hearing. So they have the divorce hearing, and for all intents and purposes, they're divorced. Everything in the separation agreement or the judgment goes into effect, but then there's another 90-day period, and only after those 90 days are these people actually technically legally divorced, and that's called divorce absolute. And so the question was, at the divorce hearing, can I get married during this nisi period? And so, I'm thinking, are you serious, first of all? And so I had to very nicely recommend that this lady step back and just give it a little bit more time before jumping into another marriage. So
Chris and I have been together almost 7 years. I don't want to get married again ever. Just the legal stuff. No offense to anyone getting married, but and I can't imagine in the middle of the process still being like, I want to do it again.
Let alone, within 3 months of actually getting divorced. No,
wow.
Don't do it. Just don't do it. It's never a good move.
No, and also I think about just this nature of toxic relationships is rushing to the next thing. Like, why? You don't need the contract. Like, just date.
Yes.
For a while.
Kick the tires for a while.
Yeah. Okay. Any other fun ones?
Well, this one isn't as much fun, but it's very common, and it's should I hang in there a little bit longer for the kids? And it's actually sad because because you have to keep in mind the potential damage that you're causing these kids when you are in an unstable / toxic relationship. And even if it's not at that level and there is strain and lack of trust, kids sense that, right? Like, once they're at, even younger kids, where people would think, he's too young, he's only 3 or she's only 4. Kids sense that atmosphere and that environment. And so I think that, sadly, what a lot of people do in the name of stability and consistency in their minds, they stay in a little bit longer than they should because they think that they're doing what's best for the children, and they're actually not. It's very difficult to measure the damage that that's doing, but you're modeling for these kids. You're modeling that it's okay to be in a dysfunctional relationship for a long period of time. The anxiety and stress and strain that these parents are feeling are trickling down to the children and causing psychological harm. So I think that it's just very important to keep that in mind. And what I always tell people is, if you're not actively trying to fix it and there isn't a realistic possibility of fixing it, then you should be working on an exit plan. You should be going either in one direction or the other. Either try fixing it or start working on getting out.
I am going to take that quote and turn it into a post. That's a great line. Yeah, so significant. And we've done a lot of work with that. We've done webinars on like the top 7 dangers in toxic relationships, and the stuff with the kids is a huge one. And it's not just, we say it's not just saying it's okay. It's actually teaching kids that this is normal.
Right.
That this is what a normal relationship looks like. And however young they are, they're learning that I mean, that's what they're going to go for.
Correct. And you have to ask yourself, do I want my child in a 5, 10, 20-year relationship like this? Because you are teaching your child that that's okay. And that's probably what's going to happen.
Yeah. Yeah. Okay. Any other questions, or do you want to just tell people how they can find you?
Sure. I mean, you can find us online at billfariaslaw.com. You can find us on the social channels at Farias Family Law. We have a YouTube channel also, Farias Family Law. And if anyone has any questions, feel free to reach out. Remember that we only practice in Massachusetts. So if people have out of state questions, I think it makes sense to reach out to an attorney in that specific state because laws differ from state to state. But to the
Mhm.
extent that I can, I'm happy to help.
Okay. Well, Bill, thank you so much for coming on today. I have like all these nuggets as you were talking. I'm like, I'm going to do this clip, this clip, this. It's great. That was really great.
Yeah, thank you, Lisa. And thank you again for the work that you do. And I'm happy that we have you as a resource now. I wish we'd known about you earlier, but we
That's
appreciate.
okay. I was busy doing other stuff.
But yeah, we appreciate your work, and it's very important. So thank you.
Oh, thank you again. And we'll stay in touch and maybe do another one of these.
Sounds good.
Okay. Talk to you soon.
All right, see ya.
Bye.